Now, what can we glean from some of her other rulings? Is there anything in there that we can pull out, or is she going to continue to follow that Bork rule where it's really we don't talk about anything that could potentially preclude me from getting nominated to the Supreme Court? So we have a writing. One of the first issues we want to talk about is qualified immunity. So this case comes from the Seventh Circuit Court of Appeals, and this opinion was actually written by her. This is from the U.S. State Court of Appeals, United States Court of Appeals, William Ransberger versus Charles Benner. So here's what happened in this case. We had William Ransberger, who was charged with murder for actually murdering his mother, and this detective was Charles Benner. Charles Benner was this lying detective who fraudulently put forward a probable cause statement in which he lied, which is why we say he's a lying detective. This case was decided on January 15, 2019, so not super old. It was in Amy Coney Barrett's court. She was one of the judges who was in this decision, and she actually also wrote the decision. So this shows you that she wrote it, and that's important because there are a lot of opinions, and there's a lot of people out there saying that she takes a certain position on certain things, but she didn't actually author the opinion. I think it's important here. We're talking about qualified immunity. That is when a police officer does something wrong, they say that as long as it was not, super egregious or past a certain threshold, that the officer should be protected against any criminal liability because they're an extension of the government. They have immunity from prosecution as long as they were sort of operating within the confines of their job, of their role, then they're going to be protected from any prosecution. So that's what happened with this case. The person was charged with murder, and the detective lied in the probable cause statement, which is what he needed to charge him with the crime. Once the lie came out, the detective, who was now being sued for a civil rights violation, the detective said, yeah, you can't sue me because I have qualified immunity. Yes, I did lie in that probable cause statement, but still, because of this qualified immunity doctrine that is so broad, I'm immune from prosecution. Well, what did Amy Coney Barrett have to say about that situation? Here is a paragraph from her holding. So we're going to pick this up where the detective says he has qualified immunity. The detective is asking the court to grant qualified immunity and actually dismiss this claim against him, he was being sued by the defendant who was originally charged with murdering his mother. He was later released because this case was thrown out. So the court, this is Amy Coney Barrett, she says, in response to dismiss this case because I have qualified immunity, the court says, we decline to do that. She says, Benner concedes for purposes of this appeal that he knowingly, this is the detective knowingly and recklessly made false statements in the probable cause affidavit. He emphasizes that knowingly or recklessly misleading the court in a probable cause affidavit, whether by omissions or lies, only violates the Fourth Amendment if the omissions and lies were material to the probable cause. So the detective is saying, yeah, I lied, but it wasn't that big of a deal because it wasn't necessary for me to go and make that arrest. And the court says no. He claims that his warrant, but we disagree. Materiality depends on whether the affidavit demonstrates probable cause when the lies are taken out and the exculpatory evidence is added in. And when that is done here, Benner's affidavit fails to establish the probable cause to believe that he murdered his mother because it is clearly established that it violates the Fourth Amendment. To use deliberately falsified allegations to demonstrate probable cause, Benner is not entitled to qualified immunity. So it's not entitled to qualified immunity. Now, you can take this case and you can look at it and you can say, oh, hey, great. Amy Coney Barrett found that an officer did not have qualified immunity, which is a good thing. I support that. I'm in favor of lower standards of qualified immunity or eliminating it, quite frankly. But this is a much lower standard. Now, if you read it closely, it looks good on its face, but it's also pretty narrow. It's pretty narrow. She's actually doing an analysis on some of the evidence and saying that, yeah, so in other words, there may have been a position where he lied, but they also still had enough evidence to move forward. So the lies would no longer be material. So she's having this conversation about materiality, which is concerning because that's very subjective. You can have some opinions on what is material and what is not material. And in this case, she's having that conversation. I would have liked an even more strict standard on that, saying if an officer lies, even in the probable cause statement, it doesn't matter whether it's material or not. If the cop's a liar, he's a liar. We shouldn't believe anything else in the probable cause statement because he just admitted he was lying. So that would be my sanction on the government. Say, if you lie at all, you're out. You're done. Game's over. Thanks for playing. But she's having this sort of debate about it, saying, well, look, here the lies were material. That's why we're going to say you don't have qualified immunity, versus saying, well, what happens in a situation where there's lies but they're not material? Then she would say, sure, you can lie as much as you want in these probable cause statements, and that wouldn't be a problem. So that's open for, it's kind of a 50-50 case. It's a good holding, I think, in one direction, but it's also concerning because it is quite narrow.